May it please the court, my name is Alan Wachs. I'm here on behalf of Acosta, the appellant in this matter. We ask for the reversal of the trial court's summary judgment because Acosta sought indemnity in this coverage action for losses that were in connection with claims that did not arise out of either the turnover suit or the wrongful acts asserted within the turnover suit or related to those wrongful acts asserted within the turnover suit. I would ask for 6 minutes to be reserved.
Okay, I'm trying to remind you, but you have the clock in front of you.
Yes, Your Honor. The starting point, because we're here on a claim for indemnity, the starting point has to be what was the loss. This is not a case that came before this court where the coverage action was pending at the same time as the underlying litigation. The underlying litigation got litigated through its conclusion before the coverage action was filed. So what we now have is a situation where we have the settlement, the policies at issue define loss as the settlement or the judgment. In this case, it's the settlement. And the case law tells us we look at the facts as they exist at the time of that settlement, the record evidence below, and we determine what the loss is from that. And then when we turn to these particular exclusions, we then say, do we have a loss in connection with a claim that falls within the prior pending litigation exclusions? Here, the loss that got litigated arose out of only about 3 of the 27 counts in the underlying litigation that were being asserted against Acosta. The discovery, both in the
but don't all these claims relate to removal of material from, marketing, whatever they're called, offices?
No, Your Honor, and that is the important point, because in the underlying litigation, the loss that got discovered, that is to say, what the parties were litigating in that underlying litigation for those 2-year span, that claim dealt with this conspiracy claim, this notion that Acosta and the officers and directors of marketing specialists pre-petition, which by definition would be prior to May 28 of 2001, conspired while the marketing specialist was in the zone of insolvency to harm the marketing specialist by obtaining the channel division. Then the conspiracy claim and the breach of fiduciary obligations claim and the violation of the automatic stay claim go on to say, in that 2-week period between May 28, 2001 and June 7, 2001, Acosta and Advantage and Crossmark, its other 2 national competitors, then began to hire these former employees of marketing specialists and began to service the manufacturers who were going on service because marketing specialists no longer had the employees to do it. And by doing that and engaging in that conduct, they committed wrongful acts that inevitably caused marketing specialists to lose these divisions of their business. In Acosta's case, it was the channel division was the big claim.
Counsel, wasn't it necessary for Acosta to use marketing specialists' physical property, such as laptops, to obtain his intangible property?
There are allegations of that in the 2nd and 4th amended complaint. The record evidence of what the claim was that the Creditors Trust was litigating, and including Mr. Alexander's testimony in this case, reflects no, that wasn't. Their claim against Acosta was the simple hiring of the employees, the former employees, and the simple servicing of those manufacturers who could not be serviced by marketing specialists. That wound up moving the relationships and the goodwill from marketing specialists over to Acosta, Advantage, and Crossmark as well, who were alleged to be joint tortfeasors on those claims. As a result of that, they claim that Acosta destroyed marketing specialists' goodwill. And so that particular claim did not depend on anything having to do with, and there's evidence in this record before the trial court, that particular claim did not have anything to do with any tangible personal property or possession of tangible personal property or even access to.
Okay, you use the term evidence, and I want to know what I can consider, what we can consider what the trial court can consider. You know, my understanding of the law of coverage is that in determining the duty to defend a particular lawsuit, which is broader than the duty to indemnify, you're only allowed to look at the pleadings in the two cases. Could the trial court here go beyond the pleadings, and can we go beyond the pleadings to determine the coverage issue?
Yes, sir. And I would say that in this particular case, we get to do that for a few reasons. First, the first reason is the policy itself. If you look at the exclusions, and specifically the National Union exclusions found in the record at 92-93, and the Arrowwood exclusion is found in the record at 138. And if we look at those exclusions, we're not dealing with a traditional commercial general liability policy where there's a duty of defense. Those exclusions and these policies are indemnity policies. They don't have a duty of defense. In fact, the National Union policy says there is no duty of defense. The exclusion itself, though, doesn't appear in a vacuum. It says the indemnitor shall not have to pay for any loss in connection with the claim. And so then when you look at the definition of loss, we then see that loss refers to a settlement or judgment. And then when you go into the case law of what is the loss is going to be defined in the indemnity context as the facts as they existed in the judgment or as they existed at the time of settlement. So my first point would be, before you can even go down this road to say, does this exclusion apply or not, we have to know what is the loss, and you can only determine that from the record evidence. Moreover, if we look at Arrowwood's policy language,
don't we first have to look at what is a claim?
I think we have to look at what is a claim as well.
So how did the policy define claim?
The policy, one of the policies doesn't define the claim. The National Union one does define claim. And in that definition of claim, there's a series of alternatives, one of which is the written demand for monetary relief. And the Faraday case addressing this exact issue before this court out of the Supreme Court of Delaware said that multiple, where you have one lawsuit does not necessarily equal one claim where you have multiple.
But that is not the only, that's only part A of the definition of claim in the policy, isn't that correct? Doesn't the policy go on to say, or a civil, criminal, administrative, regulatory, or arbitration proceeding for monetary or non-monetary relief, which is commenced by service of a complaint or a similar pleading? Why doesn't that portion of the definition of claim apply here?
Well, because, again, two reasons. One, if you read that portion to mean that once you have multiple claims, that suddenly, if it gets joined into a lawsuit, it becomes one claim, you create an absurd interpretation where now the presence of uncovered claims in the same suit as potentially covered claims would result in a forfeiture of coverage for everything. And Florida jurisprudence, as it deals with similar concepts in insurance law, has consistently, and the one that comes to mind most immediately is duty of defense. We say, if we have covered and uncovered claims joined in the same lawsuit, you have to